Hi, everyone. I'm immigration lawyer John Khosravi coming from you live from Los Angeles, California at 6 p.m. Pacific time on Wednesday, our regular time for having live Q&As. I don't know if we're going to do it next week or not. Probably not, but we'll keep you posted. But every day for the last 2 years now, we've been doing, every Wednesday, that is, a live broadcast, taking your questions about U.S. immigration on TikTok, on Facebook, LinkedIn, YouTube, and the recording is available everywhere. For those watching a live show, I do give away free video consultations. Those who watch live every 10 minutes or so, 3 times during the 30-minute broadcast. We'll name a winner to have a free video consultation, 15 minutes, by just liking and subscribing wherever you're watching this and leaving a comment saying consultation. That way we know you're there and you're interested. And my wonderful assistant, Kayla, will name off a person and we'll name a 10-minute mark. Other than that, if you're interested in learning more about marriage green cards, fiance visas, all that kind of stuff, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And you'll get a free ebook that's going to blow your mind. The best one out there that really goes over everything. We have our first guest, Jamila. Thank you, Camila. Probably Camila, not Jamila. Camila, I get to see you. Thanks for joining. If y'all have any questions, let me know. We're getting it started. Let's get it started. All right, so thank you everyone for joining. The immigration world doesn't stay quiet even during the holidays. I mean, we got some big stuff happening at the border with MPP and stuff like that. It's not something we get into on this show. It's not a focus on my law firm. Courage Love joins us. Hello to you too. But there's a lot of wild stuff happening in the world of immigration. Some better, some for worse, some just all over the place. There was a notice that came out from USCIS about the medical checkup that has to happen when you're doing adjustment of status in the United States, applying for a green card in the United States. Typically, if you need to do a medical checkup, if you do the medical checkup after filing the case and starting the program, that's fine. But if you do the medical checkup before filing the case, the signature of the doctor on the medical checkup has to be within 60 days of filing the adjustment of status application. And because errors happen, delays happen, I almost always want my clients to do the medical after we submit the case, unless it's like a certain rare exceptions, like employment-based cases, parents of U.S. citizens. Sometimes I like to include that in the initial application. But under the circumstances, USCIS is taking off that 60-day requirement. So that's interesting. So if it goes past that, you submit it within the right period of time, 2 years or something. I can't remember all the details because I just don't recommend it to people, so it doesn't really pop up. But just be mindful that exists. If you want to do your medical beforehand, there's a little bit more time for those kind of cases. Now we have some questions popping in, so I'll just jump into that. Stephen asks, when can I expect to get the 24-month extension letter for my I-751? I already received my 18-month extension letter. So I-751 is removal of conditions. This is when you have a marriage-based green card that you get, the green card is issued within 2 years of the marriage date that you got married. So they want you to do another application 2 years after getting the green card called Form I-751 removal of conditions. And when you file it, it takes them a long time to make a decision in most cases. And it's taking so long that USCIS at first said, we're going to give you an automatic 1-year extension on your green card. By the receipt notice you get, it says 1 year automatic extension. They increased that to 18 months. Now they increased it to 24 months or 2 years. What I've seen with my cases is all new cases that are filed get the 2-year or 24-month extension automatically. But on the other side, we about a month ago, we got a bunch of receipt notices for all my other cases saying, okay, now it's 24 months. So you should be getting the 24-month extension as opposed to the 18-month one any day now. It depends on when you filed it, I guess. But it's coming, and I can't say it's coming because they might forget about you, it might not. If your extension letter does expire, let's say it was a 24-month one, it expires, you have to contact USCIS, do an InfoPass appointment where you take your passport and they stamp an ADIT stamp, or we just call it a green card stamp, in your passport to hold you over for travel and employment purposes to let people know you have a green card. But when you say, when can I expect it? It should be coming anytime now, but it may not come. It's just not a fully reliable system. It doesn't work 100% of the time. But thank you for your question, Stephen. Adonis asked, the interview waiver includes F2A interview. The interview waiver, there's very few interview waivers. It depends. USCIS may do an interview waiver for F2A category in the United States. If you're thinking about the embassy, rarely, if ever, do they waive the initial interview because by law they're supposed to do it. Sometimes they're minors, they may not, but they usually want you to come in at the very least. So it depends on if you have an adjustment of status case or consular processing case. If consular processing, you probably still have to do an interview. If with USCIS adjustment of status, it's 50-50. I've seen cases had to interview, I've seen them not. But because F2A is if it's F2A minor child of a green card holder, maybe not. But if it's F2A spouse of a green card holder, majority of the time, almost every time, they'll do an interview on that. So chances are you're going to have to do an interview, so be prepared for that. Camila asks, yes, I do have advent for my fiance. For the past 2 years, he just stepped down the medical and all the paperwork. How long do you think you're going to take the call for an interview? I don't know. It just depends on your local office when your interview is going to be called. There's no consistent thing. Sometimes they happen really fast. Sometimes they happen really slow. So I don't get into how long things are going to take because we just don't know. It's unknown. COVID Khalid asks, hi, John. You said biometrics have been applied for my case. What does that mean? That means you did your fingerprinting appointment, the biometrics, and the government absorbed the information, and that's it. They connected your fingerprints with your case. That's it. It's more of an internal thing. I'm not sure why they even update people on that. Jordan A350, one of our regulars, asks, hey, John. Hey, Sir John, what's up? Good to see you. Is consular processing generally less expensive and easier compared to adjustment of status for a normal case with no issues? No, consular processing depends on what do you mean for less expensive. So on a basic case, for like a marriage case, if you're doing adjustment of status, the filing fee is $1,225. You have to do a medical checkup, and it might be more stuff, but let's say it's a clean case. If you're doing consular processing, it's $445 to start, then $220 to get the visa, the green card printed once you're done. So the filing fees are almost cut in half when you're doing consular processing as opposed to adjustment of status. But for consular processing, you'll need police certificates, maybe more translations of stuff and the such, or travel to the location. The doctors may be more expensive. So the government fees, if that's what you're based on, yes, it's less. If you're looking at attorney fees, and I can't go into what fees are exactly here, but I charge more for consular processing because I found it just takes more time, both the application process, preparing someone for the interview, and dealing with the consequences and the headache of what happens after the interview at the embassy and the wildness of dealing with the Department of State in the process of consular processing. So when it comes to government filing fees, the fees are less. But if you're talking about attorney fees, at least in my office, consular processing is more expensive. Courage Love asks, so I was going to go to my interview on the 17th, and I already had a ticket to travel on the 20th of this month after the interview. Can I travel? I don't know, Courage. I can't give you individual legal advice. I don't even know what kind of interview you have and what's going on. So I can't really answer that question. That's too individual. It won't be appropriate for me to answer that. D Park asks, pros and cons of having an independent EB2 and EB3 adjustment application for national and backlog lanes. I don't know. I mean, just depends on your case. There's no pros and cons. If you want to file both of them, then you file both of them. Why not? That's about it. The visa, the thing you're worried about in these backlog things for these employment-based cases is if you're guessing from India, and the visa bulletin chart, the line that exists for EB2 versus EB3, sometimes one goes faster, sometimes one goes slower. If you have valid cases for each category and you want to spend the money on having two applications pending, you have employers for that, then go ahead. But I don't know. It really depends on your individual case and how much money you want to spend, really. Yes, I got that. So thank you, Dr. Park. Hope that helped. Now, Zia asks, hi, John. How long does it take for siblings for Pakistan things? Well, it's going to take a long time because sibling cases, if you're a U.S. citizen and you're applying for your sibling in a foreign country to be able to come to the United States, that's going to, wait, I don't know, at least 15 years, 16 years. It varies how long it takes. But it's going to take more than 10 years, 10 to 20 years, somewhere in between, if they were born in Pakistan. So it's based on the place they're born, automatic 10 to 15. But if they're born in India or Mexico or Chile, I have to see the F4 category for that, or Philippines or something like that. They're even longer. Now, Zia asks, is public charge still apply? So does the public charge still apply? Yes, the public charge always has applied. It will apply. The public charge is something that was one of the first rules for immigration, I don't know, 130, 40 years ago that was passed. I said if a person comes here, they have to be able to support themselves and not become a public charge. The U.S. public doesn't have to pay for them. That rule is still there. Form I-864 application affidavit of support is still there, or the I-134 affidavit of support for non-immigrant visa is still there. What is different is the interpretation of how to enforce the public charge rule. And so during President Trump's time, he made it much more difficult and strict on who could pass the public charge test. This was pulled back under the next administration's current administration, but it's still there. So, for example, if you're applying for a student visa or tourist visa, and the officer thinks that you're coming here to go to the hospital, for example, and not pay, yeah, they can say you're going to be a public charge and deny you. Or on the other hand, if you're married to a U.S. citizen and you're applying for a green card, and the U.S. citizen spouse doesn't make enough money, and you don't have a joint sponsor or assets to be able to show that you could financially support your foreign spouse, then the public charge is going to apply, and they're going to, or at least initially, refuse the case until either you'll get an RFU with USCIS. If you file like that, insufficient documents like that, they'll give you a limited time to respond. Or at the embassy, they'll give you a refusal and give you administrative processing to respond to that. So, at the 10-minute mark, I want to announce the winner of our free video consultation, Courage Love. Please take a screenshot of where you're watching this and email me at info@jqqlaw.com. And so I know it's you. Make sure the screenshot has your username in there, and I'll send you an email with a link to schedule a private video consultation. So those just tuning in, we do give out free video consultations. We have 2 more left, one in 10 minutes, one in 20, where you could talk privately in a video consultation, 15 minutes about your case. So all you need to do is like, subscribe, and leave a comment saying consultation, and I'll announce the winners every 10 minutes or so. And if you're thinking about doing a marriage-based or fiance-based visa, really go check out the information, learn the process first before you even interview attorneys, because you want to know what you're talking about, frankly, and see if the attorney does as well. Download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. All right, we'll take the next question. Oni Law asks, cases for the U.S. Embassy, how long will I have to wait for my interview date? My mother filed for me. I don't know. First, I need to see all your documents, but at the end of the day, the embassies are all over the place with scheduling. So I don't have an answer for that. We can talk in private if you want to schedule a consultation, but at the end of the day, when the embassy is going to schedule an interview is up to the embassy. I don't know what the answer to that will be. Tanya asks, ICE is still arresting on the spot at I-130 interviews if they're under removal proceedings. I'm in New York. It depends on the case, so not always. I would refer you to, I don't handle cases where someone has removal proceedings, so it's not something I see. I just hear colleagues talk about. It does happen. It depends on the field office if they allow it, and it depends on the person if they have certain issues or they're just unlucky and ICE spots them. So I would it could happen. At the end of the day, they could have stopped the program for 3 years, and then the first day they restart it is the day that you go to your interview. So if you have an issue on removal proceedings, it can happen. They're not supposed to. For example, if you're going to do an I-601 waiver, a 601A waiver, typically they don't do that, but they have the authority to do that, particularly to hold off on that. But they can make an exception and be difficult for you. Okay, Shahid asks, hi, I have a question. My I-751 case shows that they scheduled my interview 2 months ago, but they still not send the letter. Do you know how long it takes for the interview letter? Well, that's really serious, because if they sent you that they scheduled you an interview, usually the interview is like a month after you get that notice, or 6 weeks. If it's been 2 months, you may have not got the letter and you have missed your interview potentially. So it's very, very important that you call USCIS tomorrow morning, first thing in the morning, the 1-800 number on your receipt, and immediately talk with them to say, I never got the notice, to confirm with them so that they don't deny your case automatically and potentially send you to removal proceedings. So it's really serious, and it's one of the reasons it's good to have an immigration attorney, because the lawyer also gets a copy of the file. So if it didn't arrive at your post location, which happens all the time for when it comes to USCIS letters, that at least your lawyer gets it. But having said that, you need to call USCIS immediately tomorrow morning when they're open. Tell them what happened. Make sure that ask them when the interview is. If they'll tell you that, they probably won't. But at the very least, get it on paper, at least on phone call, that you didn't get the notice, to try to reopen the case if it's been automatically denied for not coming to an interview, and try to get ahead of that ball before it gets too far. A paranoid Andrew, really quick for that, says also you're only dealing with USCIS usually, whereas counselors USCIS. So you get some good points from paranoid Andrew, one of our regulars. Musi asks, after my biometrics and after I submitted RFE, USCIS said they're reviewing my case activity, and and nothing is outstanding this time. Is that a good thing? It's not a good or a bad thing. It means they're just reviewing your case. So you just need to wait for them to finish reviewing your case. Mario asks, I passed the citizenship interview, but decision cannot be made 5 months. Still hear nothing from USCIS. That happens sometimes. Now, after you pass the 4 month, you could file a lawsuit against them, but you could try sending a letter to the office saying what's going on in my case, or filing a request by calling USCIS online. Or after that, if that doesn't work, contacting your congressperson to push them to make a decision. I don't know your case. So when you say you passed your citizenship interview, that you technically haven't if a decision has been made yet. So you haven't passed your interview. You might have passed a portion of it, like the reading and language requirement, but you haven't passed your citizenship interview because the decision's not been made yet. So you need a first. I mean, if I was you, I would first talk with the immigration lawyer too to review the case to see if there's something weird that stands out. Sometimes I have a clean case right now. It's been a month and a half, no decision. It's very annoying. But if it's gone 5 months, they probably found some issues. So you really need to talk with an immigration attorney, and then start contacting USCIS, congressperson, senator, see what's going on, and potentially filing a lawsuit. Political asylum lawyer says, "What's up, John? Hi, good to see you, brother. Good to see you." Musi, at this time, so sure. Okay, are you, Henry Paranoid asks, are you seeing a lot of delays or administrative processing refusals as consulates more than ever? Well, I'm not really seeing too many interviews at the consulate, so I'm not really seeing administrative processing. So when it comes to consular processing, most of my cases are just stalled, and when they're at the embassy, and they're not scheduling the interview. We're just starting to get a couple of things moving forward, but for most parts of the world, unless that case has an expedited or emergency situation, interviews just aren't being scheduled in many places. Code follows up. On the average, how long does it take for USCIS to transfer a case to the National Benefit Center after, I think you meant the National Visa Center? The average is, 2 weeks to 2 months. It's a kind of pretty average, but sometimes we get approval notice, and the next day we get the National Visa Center notice, and sometimes it takes 2 months to come. So it's all over the place. Now, I have sometimes where they put my email address incorrectly, so I don't get the notice, and I think it's not coming. But my clients do, and they inform me that they got it. So maybe they put the wrong email address for you too. So if 2 months pass by, you have to contact the National Visa Center to see what's going on. One other note is we see things pop up where someone filed a Form I-130 petition, or even maybe I-140, but I-130 in particular, family-based, and they mark that the person is in the United States or is going to do adjustment status. So USCIS does not send the application to the overseas location embassy, and that becomes a problem. Or sometimes, even if you did it correctly, USCIS sometimes mistakenly holds on to the file, doesn't send it to the National Visa Center, the NVC. That becomes a big time-consuming issue to kind of solve. Hopefully, that didn't happen to you. Pratt asks, do you provide some counseling for N400? Yeah, N400 naturalization application is something to do consultations for. If you have a lot of criminal history, arrests and stuff, I typically don't do those kind of cases. But generally, the N400 application naturalization, the application to become a citizen, is something my office does. You can just email me at info@jqqlaw.com, and we can schedule a time to talk about that, Pratt. There are consultation fees, but just email me, and we can take it from there. Now, yes, if I U.S. citizen and sponsor, if I am a U.S. citizen, I sponsor my brother, and I'm taking Medicaid, so public charge apply on me, it makes me a problem or not. So if you're a U.S. citizen taking Medicaid, that's fine. You're entitled to that. Your brother can't come and take that as soon as it comes in or something like that. So that's not going to be taken into consideration. But if you're on Medicaid, you might not be making income, which would be a problem for public charge. So you'll have to get a joint sponsor in that kind of case if you're not making enough money, and the joint sponsor will have to be part of that process. Girl Mom asks, are they interviewing for I-751 cases? Yeah, they do that all the time. Tanya asks, where are you located? I'm physically in Los Angeles, California, and my associate Unedited is in Washington, D.C./Virginia. So we're on the East and West Coast. Just email my office with the issue that you have and your location. And if it's the type of case where a lawyer doesn't need to be where you're at, then we could just do it. So a lot of my cases are all over the country. My location doesn't matter in the cases that I do. Mariana asks, how many RFEs? Mariana Puffco. Next question asks, how many RFEs does USCIS send? I don't keep track of these kind of statistics for USCIS. If you go to uscis.gov, they may have breakdowns of this kind of stuff. Hayati asks, hi, sir, my I-130 petition. Let's go back. Hayati asks, hi, My I-130 petition was filed on August 30th, 2021 online, and it's at the Texas Service Center. It's still showing received. My spouse is a U.S. citizen. How long? If you're doing a U.S. citizen marriage case, typically 6 to 10 months. But you might get an RFE. Could be longer, could be shorter, but average 6 to 10 months for a U.S. citizen-based marriage case. I-130. Z asks, hi, after marriage, when I apply for citizenship, I have 10-year green card. I got green card March 21st. I'm not sure what your question is, Z, but I think you're asking when you apply for citizenship. I don't know when you can, but I have a really detailed video about this on YouTube. If you just go to JQK Law's YouTube page, which we're probably on right now, and just type in naturalization time and all that kind of stuff, how long naturalization, how long citizenship, you're going to find a really detailed video that's going to answer your question. Now, it doesn't go into the 3-year as opposed to the 5-year green card. It really focuses on the 5-year base, but just take the information there and when I say 10, make it 3. When I say you need to be in the U.S. physically 2.5 months, cut that in half, 1.25 or something like that. But I would need to talk to you in person, tell you exactly what's going on with your case. We do video consultation, not in person, but I see you. Practice, thank you. You're welcome. I do want to announce our winner of the free video consultation lottery, Musi Kadanu. Thank you so much for watching. Please, take a screenshot of where you're watching this so I could see your username and email it to me at info@jqqlaw.com. I'll have a no-cost free video consultation, 15 minutes to really go over your case to see what's going on and give you some more private attention. For those just tuning in, I give out a free video consultation raffle for the live show. We have one more to come out. If you want to join and be part of it or get your name in the thing, do like a great consultation where you're watching this, like, subscribe, and we'll see your name. My assistant Kayla will tell me. Now, Courage Love is asking questions here. Courage, you are the winner of our first raffle about 10 minutes ago. So I just want to talk with you in private. You don't have to go with your stuff here. We'll just talk then and do it. But really quick, let me see if it's let me see if it's something urgent. So I'm talking about citizenship interview on the 17th, and I would take a travel. Can I travel afterwards? Yeah. So I got to talk to you in private. I wouldn't travel because it could create. I need to just explain it to you. Okay, I'll explain. If this is a situation, we'll talk privately too. So we have a lot of clients who there's two situations. They have a green card interview and they need to travel afterwards, and they have a citizenship interview they need to travel afterwards. Let's hit it at citizenship first. So once you do your citizenship interview, let's say you're approved on the spot. If you are, you still have to do an oath ceremony to become a U.S. citizen. And that oath ceremony could happen on the same day, it could happen 3 days later, or it can happen 3 months later, whenever they want to do it. And so what's important is that once you do your oath ceremony, you have to give your green card back, and they give you a naturalization certificate, a piece of paper that says you're a citizen, but not a passport. So if you have to travel internationally, you got to get a passport first. You can't leave and come back anymore. You don't have your green card. So the next problem that comes up are the delays with the Department of State for issuing passports. So even if you become a citizen, technically you get your naturalization certificate, it could take months to get a passport. So let's say you get interview on 17th, you're approved on the spot. You got to make sure you don't do your oath ceremony before you travel and come back. But we don't really want you missing oath ceremonies. A lot of times, if you miss one, it's not a big deal. It depends on your local office, how strict they want to be. But they may reschedule one soon afterwards. If you miss that, the whole thing might go away. So you gotta take some risks and see what's going on, see what you want to do, or even tell the officer, don't approve my case, hold police for another week or two because I need to travel, talk with them. There's different things, but that's the basics. Now, if you were doing a green card interview, I don't want people traveling because after the interview, your case might get denied and you're stuck outside the country potentially. And on the other hand, even if you're approved, then your green card's not with you. If you travel, you need to come back to the green card. If you have advanced parole, probably you can play it off. So generally, you don't want to travel after the interview. There's some risks and stuff. You kind of have to play it by ear if you want to take some more risks. But that's a quick overview of that. So IO asks a regular, good to see. I'm working on OPT and I just put an adjustment application. If my work permit comes first, can I work with it? Will it affect my OPT? So there's different opinions on this. My opinion is if you have OPT and you get a employment authorization document and work permit based on the adjustment of status green card application, if you leave your OPT work and do some other work that's not in line with what the OPT designated work is, then I believe your underlying status will be affected, be violated. Some people don't think that, but that's I'll be conservative. So if you have an adjustment case, you get the work permit based on adjustment, you change your job, you don't update your school CVIS that you change your job and get permission from your DSO, designated school official, then in my opinion, it'll cancel the first OPT in a sense. Not don't cancel you per se, but like it's a violation. You're not using it properly, all that kind of stuff. Dr. Ahmad says, I applied for the NIW I-140 concurrently with the I-485 in 2019, and both have been pending since that time. Then I got a job at a university, applied for my I-140 based on a labor cert. Well, if you got a job at a university, you want to do an I-140, EB-1A, EB-1B I-140 if you're working at a university instead of doing a labor cert. But your question continues. Then you got it approved this year. Now, how to make my pending I-485 based on the approved I-140 from the university? Is it I-485J? No, you do need to eventually probably file. You don't need, if you file the I-140, it's approved. You do need to file an I-485J when you file your regular I-485. But there's a way to take an existing I-485 and move it to the other category. I would prefer that you just spend the money and file a new adjustment of status application, because it's still, they'll do it normally where you take an existing I-485 and just move it so you don't have to spend the money again. But it's discretion, and they could forget to do it. They could not know how to do it. They could all mess it up. So generally, if you have an I-140 employment base approved already, I would just file a new I-485 application for adjustment of status with that one. You need to file I-485J with that, but that's something different. But that's what I would typically do in this kind of case to be safe. There's just a lot more we got to review in your case, just to case specific. But generally, and this kind of ideas, many of our viewers don't understand. So I'll do a brief review of it, I guess. So when you're doing an employment-based case, there's an I-140 as opposed to a family-based, which is I-130. And this person had an I-140 pending based on one type of employment-based case. It was at EB2C. But he got another I-140 employer kind of filing for him, an EB2B or EB2A right now. And so this is getting too complicated. I don't want to go into it. But nonetheless, I hope that answered your question. It's better to file a new I-485 typically, but I'll need to talk to you in private for more. Khalid asks, can an applicant be denied based on medical for having latent TB infection with normal chest x-ray? All their tests are okay. And which brand of COVID vaccine are approved for medical is AstraZeneca? There's a website that lists the COVID vaccines that are approved right there. The doctor who does your medical will know, and they'll do it. But with regards to denial for latent TB, no, if your chest x-rays are good and the doctor gives you the okay, that's fine. There are waivers for typically for TB infection and things you could do to control it, which are okay. So that can be dealt with. But if your chest x-ray is okay and the doctor gives the okay, it'll be listed on the I-693 if you're doing adjustment. So just check that out, get a copy of it, see what they say. But probably it'll be okay. And I don't keep a running list of which COVID vaccines are approved. So just check that out online. Dr. Perry follows up, if you have an employment-based AOS-based EAD approval, any reason to keep extending H-1B for safety in case of AOS denied in the future from people in backlogs? Yeah. If you have an H-1B, keep renewing. If the employer wants to pay for it, why not? So you have a green card case pending, it's not approved, but you want to keep the underlying status that you had alive as much as possible. If you feel like spending the money, that's a safer thing to do, yeah. Because you never know what's going to happen with adjustment. You'd probably be okay, but why not be safe? Tanya asks, waiting for an immigrant visa interview in Haiti since December 2019. Have you got any interview dates from Haiti after COVID? Fortunately, I haven't had any Haitian cases. I've been hearing delays from people watching the show saying that Haiti is taking forever, but I just don't have any cases from Haiti to be able to answer that. So I don't know what the timelines are or what's going on there. Yo follows up. My wife is a green card holder and I'm on OPT and we submitted adjustment of status at 765. You should have done I-131 probably too. But if the work permit at 765 is approved, can I work with it elsewhere as a part-time? Will still do my OPT under my until my green card comes. If you got OPT, if you got an EAD based on your green card case, you could work 5 different jobs part-time if you want. That doesn't really matter. You don't have to keep the underlying status if you don't want to. It's better you do, but whatever you do, if it's a good case, then it's not a big deal. Yvette says, hello, I have an I-589. It's asylum pending for 4 years. I'm married and filed U.S. citizen. I filed adjustment status at I-130. No interview scheduled. They said I need to withdraw my I-589. They called and said that. I hate it when they do that. It's no requirement that you withdraw your I-589 to be able to process your adjustment status case. You need to contact and say there's no requirement for that. Talk to a supervisor. That's appropriate because if your adjustment of status gets denied, because they might say that and then you don't have the underlying I-589, then you're in big trouble. So I would need to see the case sometimes to avoid arguing with them. If I know the I-485 I-130 is appropriate, then we do that. But I don't know enough about your case. You might have incorrectly and improperly filed an I-130 I-485 combo. So they might deny it. So I can't tell you what to do. I like to argue with them if they're going to tell you to withdraw the I-589. Some officers do that. In my opinion, that's incorrect. I would challenge them to show me where that requirement exists. It's hard to get a hold of them and talk to them, so that becomes a hassle. But I think that's inappropriate for them to make that request to you. I haven't seen the regulations that say that. They may be there, but I haven't seen that. I've only heard people say that. I have cases where people have asylum pending and we file for adjustment of status, and I don't withdraw the I-589. Never had a problem. I've had colleagues say they've had this asked of them, and if it happened to me, I would argue with them about this because I just don't see where that's a requirement. Thank you for your question, Beth. Mayan asks, somebody filed divorce, can he or she withdraw before interviews? Yeah, if you have a marriage case pending, you file for divorce, and the I-130 petitioner can always withdraw the I-130 petition. That is their case, so they're allowed to do that. So we reached the end of the show. Dr. Imad Tahamuni, please, thank you for coming on the show. Email me at info@jqklaw.com. Take a screenshot of where you're watching this, and we can have a little quick private consultation and talk about things and see what's going on in your case. It's info@jqklaw.com. If you just email me there. For everyone else, if you want to schedule a private consultation, email me there and briefly explain the case issue that you have so I know what kind of case it is. Then we'll take it from there. Thank you so much for watching. Have a great rest of your holiday season, or may not be back next week. We'll see what happens. But until then or the next one, God bless, be safe, and have a happy holidays. See you soon. Bye-bye.